So welcome. We had over 30 people register for this. About half would be planning commissioners and the other half are assorted members of DRBs or select boards or zoning administrators and administrative personnel. We probably have so many participants that it'll be unwieldy to do just free form question and answer throughout. We have several slides built in to stop and take questions after the various segments of the presentation. And Sue's going to be monitoring the chat, the participants in the chat. So if you have questions, feel free to put them in the chat or raise your hand. We'll do our best to accommodate them timely, but we'll see how many end up arising. There is going to be, or will be, a survey link, an evaluation form survey link posted in the chat. We'd very much appreciate it if you took a couple of minutes, and literally it's only a couple of minutes, to take that survey. And as I mentioned, these proceedings are being recorded. So with that said, the presentation this evening is about the basics of town planning in Vermont. And we have a couple of different sections. One is planning itself, what you may do and how you should do it, the roles and responsibilities of the various different players, the parties involved, from planning commission to select board to DRB to zoning administrator, means to implement the plan, regulatory and non-regulatory, and then a brief section on public meetings and hearings and due process. So with that, the first most important thing to mention is that in the general context of land use planning in Vermont, Vermont's a Dillon's rule state. Many folks think it's home rule state. It's not. A Dillon's rule state means that towns can only do things that are actually enabled, authorized by statute for them to do. And if they're going to do them, they have to do them as specified by statute. So that means you have to engage, for example, in public hearings about adopting a plan or adopting bylaws. The statute enabling and governing land use is planning in Vermont is Title 24 of the Vermont Statutes Annotated, Chapter 117, also known as the Municipal and Regional Planning and Development Act. There are sort of three elements, or the legs of a proverbial land use planning stool. There's the statute that authorizes plans and implementation tools. And then the plans themselves, authorized by statute with specific required components, and then implementation tools, both regulatory, zoning, subdivision, flood hazard area bylaws, and non-regulatory. And we'll get into more details about those in a little bit. Brief history of land use planning and regulation in Vermont. 1921, the legislature authorized towns to create planning commissions that could draft town plans. 31, the legislature first authorized zoning. 68, Chapter 117 was actually established and included purposes of planning and zoning and specified required contents and processes. In 1988, Act 200 updated portions of it. And in 2004, there was another update that incorporated additional facets of the zoning portions, substance and process. What is a town plan and why have one? Town plan's a document that helps a community define its vision for the future and provides guidance for achieving it. Hopefully, provides guidance for achieving that vision by means of various activities the town can undertake. In essence, a plan provides policies to guide orderly growth and development. Why have one? Well, to develop a community-wide vision, and a plan empowers the community to respond to changes in ways that reflect the values, goals, needs, and priorities, and to designate particular areas for conservation or development, those areas that you want to see stay the same or change slowly or change more rapidly. Having a town plan enables towns to do things. You can adopt and amend zoning, subdivision, and flood hazard regs. If you don't have a current adopted plan, you cannot adopt or amend zoning and subdivision and other regs. They don't disappear, but you can't update them unless you have a current adopted plan. If you have an adopted plan in Act 250, any development projects being reviewed under 250 can only be permitted with a finding that the proposed project conforms with the town plan. In section 248, application or petition for a certificate of public good for energy projects, recommendations of the town plan are given due consideration. Or if you have an enhanced energy plan, you may be given substantial deference, which is a potentially significant improvement in your standing. And having an approved plan, and we'll get to what that actually means, is essential to be eligible to apply for certain state grants and designations such as downtown, designated downtown, or designated village center. The planning process in general is iterative. You adopt a plan, you implement the plan, and then evaluate the plan and the planning program on your way through trying to implement it, and then collect and analyze background information and data, establish goals and objectives, outline policies and actions to achieve the goals, and those can be summarized in an implementation program. So the state statute specifies 4 general planning process goals and 14 specific, very specific planning goals. The process goals, I'm not going to read them all, but essentially to establish a coordinated comprehensive planning process with citizen participation and consider the impacts of it on the region and the state as well as the town, and to encourage towns to work creatively together to do their plans. And the 14 specific state planning goals, and these are paraphrased, but they're all elements that a town plan, if you have one, must be consistent with. So flood resilient communities and wise use of resources and the land use pattern, reflecting compact villages and rural countryside, strong and diverse economy, and so on. Talking too much. So the importance of citizen participation can't be overemphasized, and there are a number of ways to to engage in citizen participation, get the information out through fact sheets, newsletters, websites, consult with folks, solicit and provide opportunities for input, and try to have opportunities for dialogue and interaction, and collaborate with folks to develop alternatives and identify solutions. There are the 12 required elements of a plan, and I won't read them all, but these, if you're going to have a plan, it must contain all 12 of these elements. As an aside, the legislature keeps adding new ones. So, for example, number 7, you had to have all of the previous 6 and then a recommended program for implementation. Then there was the addition of other things like an energy plan, and then a housing element, and then an economic development element, and then a flood resilience plan. So this is the order that they appear in statute. That doesn't mean that's the order they have to appear in your plan, but they all have to be there. So plan adoption. Town plans expire every 8 years. Up until July of 2015, town plans had a lifespan of 5 years. But after July 1 of 2015, they expire every 8 years. So it's highly advisable to update and revise or readopt. You can readopt a plan if it's about to expire. Just update the data and check on your implementation program. A word of warning to folks that are new to the process, in particular, the adoption process can take quite a significant amount of time. There have to be hearings by Planning Commission and Select Board. A hearing, it has to provide information about its proposed plan or amendment at least 30 days in advance to all the adjacent towns, and also to the Regional Planning Commission and to other parties, including various divisions of the state. Then the Planning Commission submits the plan to the Select Board, and the Select Board has to have a hearing, but their hearing cannot be less than 30 days after the Planning Commission submits the plan to them. So right away, you've got a couple of months of time built into the adoption process or amendment process. And if the town's larger than population 2,500, the Select Board actually has to have 2 hearings. Adoption of a town plan, the default mode is by a vote of a majority of the Select Board, or the legislative body, unless the voters have elected at a regular or special town meeting to vote on adoption by Australian ballot. If that has happened, then it's voted by Australian ballot until there's a vote at a regular or special town meeting to return adoption to the Select Board. And plans go into effect immediately upon their adoption. The Select Board can adopt right after the close of their last hearing. Then there's Regional Planning Commission approval of the town plan and confirmation of the planning process. And that was why there were quotation marks around approved plan. The towns don't have to request approval of a town plan and confirmation of their planning process, but they may do it. And if they do, and that would be, among other things, in order to achieve standing in Section 248. But if they do request it, the Regional Planning Commission shall approve a plan if And here's where the importance of those various requirements are. It's consistent with the state's planning goals, all those 14 goals, and is compatible with the regional plan, and is compatible with the approved plans of other towns in the region, and contains all the required 12 elements specified in statute. And the regional commission shall confirm the municipal planning process, which it seems like sort of an esoteric turn of phrase, but that is what the state's looking for if you're going to try to apply for various grants or designation of a village center or a downtown. And it requires confirmation of planning process can only occur if the town plan is approved as above. And the RPC shall confirm if the town's engaged in a continuing planning process that will result in a plan consistent with the state's goals, and is engaged in trying to implement its plan, and is maintaining efforts to provide funds for local and regional planning purposes. Wow. Good time for a quick break and solicit questions, and I'll take a quick sip of water.
I don't see any questions in the chat, John.
Okay.
Let's see if
And
anyone's raising their hand.
Oh,
I don't see any raised hands either.
I'm getting a message that says Maya Asagawa raised her hand.
Oh,
So fire away.
My question is, can you have a, and maybe you're going to answer this later, and if you are, just tell me. Can you have a town plan without zoning regulations?
Absolutely. Absolutely. We have lots of towns that have a town plan. Well, not lots, but quite a few towns that have a town plan and do not have zoning. So hopefully that answers your question in a straightforward fashion.
Yep.
All righty. And Tom, I see your hand up.
Yes, hi, thank you. Thank you for putting this on. My question is about the enhanced energy plan allowing in section 248 review towns to have, what were those two terms, to have
Substantial difference as
right,
opposed to due
instead of due
consideration.
consideration. So is that actually defined and tangible somewhere, or are we just relying on those terms only?
So the short story is, I'm not aware of there having been case law that definitively decided it, but basically substantial deference means, if you burrow into the guts of Title 30, substantial deference means that absent a finding by the Public Utility Commission to the contrary, it's presumed that the town's plan considerations are valid and control. So,
Okay.
but I don't believe it's been sorted out by the courts yet, but that's the intent of it. So due consideration means they just at least have to acknowledge the fact that there's a town plan and it has provisions that might be applicable to a project. But substantial deference means that absent they're making a finding that there's a reason to override the town plan controls.
Okay. Okay, thank you.
Indeed. Any more questions before I zoom on to the next section? All righty. So local roles and responsibilities. There are sort of three levels. There's a legislative function, which is planning commissions, and we'll get, this is detailed further in a coming slide, but is actually writing and or adopting plans or bylaws and so on. And then there's quasi judicial function, which is the permitting side of things, where a board, an appropriate municipal panel, be it a planning commission in some instances, or a zoning board of adjustment in others, or a DRB, actually review applications and decide whether to approve the project. And then an administrative function, which is either just issue or deny or refer an application to, if it's being referred to a quasi judicial board. So the legislative body, the select board, mostly does purely legislative stuff. Planning commission has a legislative function, as in drafting a plan or drafting a bylaw. And then in the quasi judicial function, it's either a development review board or a combination of zoning board of adjustment and planning commissions. It used to be just zoning board of adjustment and planning commission, but the legislature saw fit to enable a development review board that takes on all the possible quasi judicial functions from a planning commission to free them up to devote more time and energy to the actual drafting of plans and or bylaws. And then on the administrative side, there's a zoning administrator who can issue permits in various circumstances or deny them. So legislative functions in more detail: planning commission prepares the plan or zoning, and it may prepare a capital budget and other studies. And the select board has a very important role. It reviews and it may edit the town plan that the planning commission has submitted to it. And then it either adopts it or rejects it, or if a town has voted to do it by Australian ballot, the select board would send it to the voters for adoption. And similarly with zoning bylaws. And they are the ultimate authority in terms of adopting a plan or a bylaw, and similarly a capital budget and program. And then here's a more detailed breakout of the quasi judicial functions. It used to be just there were planning commissions that largely tended to site plan, subdivision, and lots without frontage, and then a zoning board of adjustment that handled more complex issues, conditional uses, variances, and appeals. But if there's a DRB and the town select board can create a DRB, then that takes on all of the quasi judicial functions, and the zoning board goes away, and the planning commission is freed up to devote their energies to drafting, updating plans and bylaws. The administrative functions, the zoning administrator issues or denies permits and conducts enforcement, and is to assist applicants in the permitting process. And they may, depending on the town, provide staff support for the DRB, Planning Commission, or ZBA. Any questions about the roles, functions, and responsibilities? And I see Tom's hand is up. I don't know if that's residual or a new one. No questions? No questions in the chat, Sue?
I don't see any.
Okay. Well, we'll move expeditiously along.
Good.
Implementing the plan. There are two means of implementing your plan: regulatory and I don't have to read the words to you, but, or non-regulatory. I think that there's becoming an increasing interest and emphasis on non-regulatory implementation. So regulatory implementation can be by zoning bylaws or bylaws adopted under Chapter 117, or by ordinances or rules, which are adopted under a different chapter of Title 24. And so bylaws that are authorized by Chapter 117 include zoning, subdivision, flood hazard area regulations, and so on. The ordinances or rules are essentially authorized under police powers of the municipality. So there's a vast array of things, from dogs to garbage and so on. And it may include land use regulation like flood hazard area bylaws. And they may be enforced as civil under the Judicial Bureau or criminal. So why have local land use regulations? To implement the vision of your plan. And these are generally regarded as desirable outcomes to try to achieve. And I don't think I need to read them all. I imagine folks can read them just fine, but to promote compact settlement areas and good pedestrian access and protect resources, minimize fragmentation, and provide for affordable housing and efficient infrastructure, and make the community more flood resilient. There are significant limitations on local regulations. Towns can only regulate what's enabled by the statute, referring back to the Dillon's rule status of Vermont. So any land use regulations under Chapter 117 must comply with required provisions and prohibited effects, and also respect the limitations on municipal bylaws. This would be a deep dive into the weeds to go into all the various subsets in each of those two sections. But there's the reference there, and I highly encourage anyone that's considering zoning bylaws to take a careful look at those sections of the law. As a sort of general observation, while land use regs tell people what they can and can't do with their land, they can't deprive a landowner of all reasonable use of their property. So participants and processes potentially involved in local land use regulation. So the zoning administrator would receive an application and might find that it satisfies all the requirements of the bylaw and can issue a permit. Or it may not, and he can deny it. He or she could deny the permit. And the applicant has an opportunity for appeal of any decision of the zoning administrator. Or the zoning administrator might say, this requires a conditional use permit or site plan approval or something, and refer it to the appropriate quasi-judicial board, be it a DRB, ZBA, or planning commission. And the panel issues their decision, and then the applicant has an opportunity to appeal that. I think we'll get to it in a couple of slides, but where the appeals go, appeals of the ZA decisions go to the local board, be it a ZBA or a DRB. Appeals of the quasi-judicial panel would go to the environmental court. various types of review under local regulations. And there is a statutory definition of land development. And if you're going to engage in land development, the town can require you to get a permit. And the various different kind of uses and what the review is supposed to entail. Permitted uses allowed by right if the proposed activity meets the requirements of the bylaw. And conditional use, it may be allowed if it conforms with specific standards that have to be laid out in the bylaw. And site plan review similarly, which is generally focused primarily on the actual site design, whereas conditional use may have a whole lot of other considerations. Variances have to meet very stringent statutory requirements. There are actually 5 elements, and a project that is seeking a variance has to meet all 5 of those variance criteria. Unless it's primarily a renewable energy resource structure, and then it only needs to meet 4. But those were incredibly difficult to actually meet, but towns, many of them trying to exercise what they thought was common sense, were issuing variances that probably would not have withstood legal challenge. So the legislature addressed that situation by enabling dimensional waivers so that a town can issue a waiver of one of its dimensional requirements, be it frontage or lot size, if there's good cause, as spelled out in the statute. And then planned unit development, which allows for flexible design and modified standards. So maybe you can have a clustered development with houses on smaller lots than would be normally allowed in a particular district or zone, as long as there's ample protection of open space, be it owned by homeowners association or some other entity. And subdivision regulations essentially control the pattern of future development, and in significant part are aimed at ensuring that infrastructure is sufficient to support the planned development. So road widths and grades and drainage and so on. Regulatory decisions. So the decisions issued by the regulatory boards, there are these statutory requirements. They shall be issued in writing, and they shall include a statement of the factual basis on which the panel's made its conclusions and a statement of the conclusions. This is something that hasn't always been strictly observed by boards, but if they want their decisions to withstand challenge, they have to do this. And they must be based on specific standards contained in the regulation. A note that minutes of a hearing may suffice if they provide all that necessary information. Most minutes don't, but some do, and if they do, they may suffice as satisfying the requirement. The timeline for issuing decisions, the board, planning commission, or ZBA or DRB, after they adjourn their hearing, they have to issue a decision within 45 days. It's after the adjournment of the hearing, and if it's not, then the project's deemed approved, effective on the 46th day. The decision does not need to be made the day of the hearing. It can be made at a subsequent meeting. Some towns sort of trip over that and feel panicked that they have to decide sooner than they actually do. Anyway, so appeals under 117, appeal of the decision of the administrative officer, the zoning administrator. Appeal goes to either the DRB or the ZBA if there isn't a DRB. And then a decision of any of the boards would go to environmental court. Interested persons may appeal, and there's a definition in statute of what constitutes an interested person. The applicant, rather obviously, the town and any adjoining town, and property owners in the immediate neighborhood. And I don't know how that's actually technically defined. There are a lot of permutations about across roads or across streams and so on. And then any 10 persons can be a combination of voters or property owners with a signed petition saying we want to appeal. And any department or subdivision, administrative subdivision of the state owning property or any interest in property within a town. And I believe it also goes on to say, or an adjoining town. And then for some reason, the Agency of Commerce and Community Development. Only interested persons who have participated in the hearing may appeal. So that means that you have to make your presence known in the hearing process. The municipal board does not have to make an interested person determination. They can and often do, but they can also leave that up to the environmental court to make that decision. Were these property owners in the immediate neighborhood or were they not? And they can leave that up to the environmental court to decide. Non-regulatory implementation. So there are a number of ways to try to implement your plan other than by zoning or subdivision or flood hazard regs, including the capital budget and program, and tax stabilization contracts, development rights, various supporting plans. There could be a housing plan for a town, for example, or an open space plan, and advisory commissions, and other projects and studies. If there's something recommended in the town plan, then that's a good way to try to make something happen. All right, time for a break for questions.
John, we actually have some questions in the chat box this time. Want me to start?
All right. Yep, please do.
Yes, the first question is, what's considered reasonable use of a property?
I believe that is a question, a takings question that the Supreme Court has wrestled with. And I'm not about to try to paraphrase that off the top of my head, but basically you have to be able to make some reasonable use of the property. You may not be able to build as large a structure as you desired, but if you can build a structure that could be considered adequate for a purpose, boy, that is just a loaded question. So I will gracefully soft shoe to the side on that one and refer that to an attorney or to the courts. But in essence, you have to be able to do something with your property, or else there has to be some compensation offered if you can't do anything with it.
Yep. Okay, another question is turning property into a short-term rental considered a change in use?
Ooh-wee. I think that That is a question that many folks are trying to address, and I'm not sure that it's been legally resolved by the courts. I think that a number of towns have tried to indicate that short-term rental is different from long-term rental, and that gets into a very complicated issue of trying to define what is short-term rental and what is not. So yes, it's an issue, and no, I'm afraid I don't have a quick answer for it.
And it might be different in different towns, depending on how your regulations are written, right? If you have
Yep,
regulations.
absolutely.
Yeah.
Absolutely.
Okay, another question is, if a decision is not made at a hearing, does the board have to warn another meeting or just meet at an agreed time by the board?
I think we're going to be coming to a slide that speaks to that a little bit. Yep, deliberative session. We'll get to that in a little bit, but the short answer is, my belief is that, well, let's just go straight to that slide.
Okay, you want to answer one other question first before we get into that?
Yep,
I only have one more
Yep,
in the chat.
be glad to.
Okay, the next one
Okay.
is, what would a non-regulatory housing plan look like in the town plan?
Well, the town plan could recommend that there be such a thing created by perhaps a housing advisory commission or committee. If there were such a thing already in existence, the town plan could certainly cite it, by either incorporate it by reference or import sections of it that it thought were important to include in the town plan. I don't know if that answers the question or not, but that's my first shot at trying to answer the question.
Yep.
right.
Okay. Yeah, we can move on.
Shall we move? All righty. So, meetings and hearings. So, this is not the clearest of slides. My apologies. This is assembled, believe it or not, by many cooks in the kitchen. A whole bunch of regional planning commission staff people worked with DHCD to try to come up with the guts of this presentation. But there are meetings and then there are hearings, and they're different, substantially different, though they are gatherings of people. So meetings, you generally discuss business and or take action, and are sort of, in many cases, generally considered to be more legislative, as in a planning commission working on a draft of a plan or a bylaw as they're trying to prepare it. But all public bodies have meetings, and those have to be open. Then there are legislative hearings where the select board or planning commission or select board is requesting and receiving public comment on a proposed action, such as adoption or amendment of a town plan or a bylaw. And then there are the quasi judicial hearings, which, sorry about the acronym soup here, but parties in the public are participating with the appropriate municipal panel, which is actually a statutory term, which may mean the DRB, or it may mean the ZBA or Planning Commission that's actually reviewing proposed development. Open meeting law. These are important requirements, and there had been a number of changes to these that were in effect during the Governor's Executive Order 01-20, I think it was, the pandemic executive order. But I believe those restrictions will be lifted, I believe, as of midnight tonight. So you need to post advance notice of the meeting, and you need to make the agenda available before the meeting in or near the town office and at least 2 other designated places in town. And those can be fascinating, as in on the covered bridge or on the bulletin board outside the store. Anyway, and on the town website if the town has an official one. And most towns do, but certainly not all. And you have to let the public participate, and you have to make the minutes of the meeting available within 5 days. And that's calendar days, not business days. So look out for weekends. And you have to address complaints of violations of the open meeting law if someone complains. And here's a link to a resource, a very useful resource, Vermont League of Cities and Towns. Have a number of resources pertaining to the open meeting law. So public notice requirements, these get incredibly complicated. But for regular meetings, there's specifications in a whole bunch of sections in Title I. But there's in or near the town office and at least 2 other designated places have to have a notice out 48 hours before regular meetings. And for special meetings, notice has to be up at least 24 hours ahead of time, or for emergency meetings, as soon as possible before the meeting. And for legislative hearings, notice requirements 15 days, has to be published in a newspaper of record and posted in 3 or more public places. And it used to be required certified mailings to the applicant and adjoining property owners or affected, excuse me, let me rephrase that. Certified mailings to adjoining towns and to the state and the Regional Planning Commission had to be certified mail return receipt requested. There has been a change that allows that to be those notice to be distributed by email, but I'm pretty certain there's a requirement for acknowledgement of receipt. So I don't know that I've seen that really spelled out very clearly, but if you're going to email something out to your adjoining towns or to other folks, really good idea to ask for a acknowledgement of receipt. You may be able to set up your email distribution so it automatically sends you a notice that the thing has been read, but that's worth pursuing with care. For quasi-judicial hearings, depending on what the project being reviewed is, it's either 15 days notice or 7 days. I think site plan is only 7, but zoning and subdivision requires 15 days. Has to be published in newspaper and posted and mailed to applicants and adjoiners. And there has to be a posting within view of the nearest public right-of-way. That often occasions some questions. So the flow of a quasi-judicial public hearing, this is not a statutory requirement, but this is best advice from the consolidated wisdom of DHCD and various regional planning commission staff, and I think VLCT as well. The chair opens the hearing, applicant presents a proposal, board members ask questions, then comments from the interested parties are public, then the chair closes the hearing and opens deliberations. And those can be either in public, in a public meeting, or they can be private in a deliberative session. And then the board decides on the application and issues a written decision. So we finally got to the deliberative session. This is, as far as I know, relatively unique to Vermont provision. Deliberative sessions are exempt from the open meeting law. There's no requirement for public notice or to keep minutes. They can be public if you want, but they can also be private. And you don't have to reveal how the board members voted. The board has 45 days to issue a decision from the close of the hearing. So you can close your hearing and then have a deliberative session sometime later, but you need to issue your decision in writing within 45 days, or else the project's deemed approved. So in summary, protecting due process, provide public notice, give people an opportunity, conduct an orderly proceedings, sometimes more easily said than done. Ensure proper management of evidence. This is something that some smaller towns, and particularly in the past, used to occasionally have difficulty with, but you need to keep records of what's submitted in the hearing, keep copies of what's submitted in the hearing, or have accurate notes of what went on, and try to provide appropriate management of conflicts of interest, especially in smaller towns, but also in larger ones. This can be an issue where there might be a perception that someone had a conflict of interest. So it's a good idea to get that out in the open early, and try to avoid complications down the road. Other sources of information, a very valuable one is the vpic.info. At that site, you can find essentials of local land use planning and regulation, a valuable plan and bylaw adoption tool, which has checklists for what you need to do to observe all the statutory requirements for updating a plan or adopting a new plan. And the checklist goes on for a good 5 or 6 pages of all the various steps that you need to follow. And there's actually a handy checklist for a town clerk to follow. And then there's the rules of procedure and ethics manual. That's not by any stretch all that's available there. There are more resources there that's well worth checking out. And so if you have an interest in diving into the weeds, and I highly encourage folks to do that, check out Title 24, Chapter 117 at the legislature's website. You can always touch base with your friendly local regional planning commission. In this case, us. The Vermont League of Cities and Towns has a wealth of resources available for towns and citizens. And the Department of Housing and Community Development within the Agency of Commerce and Community Development has a massive website with lots of information and resources. And my contact information is here. You can get me by email or by telephone. And so, final break for questions. But I want to make sure that I mention. Oh, good. Okay. I want to make sure I mention so I won't forget, even though it's on the slide here. please do undertake to fill out the workshop evaluation form. That can be incredibly helpful for us. All righty, questions, fire away, Sue.
Okay, so let's see. The first question is, do you need a motion to close a hearing?
Good question. I think it's probably a good idea to be on the safe side. I'm not sure, so I would suggest at some point inquiring of legal counsel on that topic. If the town has an attorney, just to get a definitive answer. It certainly can't hurt to have a motion to adjourn a hearing. And I think in most cases, I can't think of a case where it's happened without such a motion. So let me put it that way. I would certainly recommend that you have a motion to adjourn and a vote to adjourn.
And here's a note from Maya that says Brattleboro DRB always requires a motion to close the meeting.
All right, thank you, Maya.
I have another question. Can you discuss variances and hardship determinations on properties in towns? Can a DRB or ZBA PC visit the property prior to the hearing commencing?
I think that site visits are allowed. I am hesitant to get too far into the weeds on that, but most cases where there is something that may be more effectively considered if there is a site visit, they absolutely are allowed to take place, and they are generally speaking considered to not be part of the hearing itself. So you go out and you look at the site, and then you come back and you open the hearing, and then you discuss what was observed on the site visit in the hearing. That's the way I've seen it played out.
And so everybody knows, I put a link into the chat box with the evaluation form. It's on Google Docs, but if you just copy and paste or click on that link, you should be able to get right to it. And that's all the questions there.
Wow.
Anyone else?
I'm amazed. Well, I want to thank everyone who participated, and thank you for asking questions. I hope you found it useful. I want to reiterate, some people had asked questions, will we be doing this again? And we generally do one of these training sessions on the basics of land use planning at least once a year. We may be able to do it more frequently if there's an outpouring of interest. I would say also that in the meantime, please feel free to contact us or me directly with any questions you may have. And it's possible that we could provide. Oh, okay, Jethro, fire away.
Hi, can you hear me okay?
Yes, amazingly so. Well, we could.
Okay. I turn my video off. Can you hear me now?
Yes.
Yep, much better.
I was curious with now that the state of emergency has ended, if we have an outdoor meeting, are people still able to call in and can they vote with those meetings?
I believe so, yes. I believe that while there was a waiver of the requirement to physically staff, to have a physical location and have it staffed, that is going to be lifted immediately. But there is still provision for people to attend meetings by electronic means, either Zoom or by calling in. I think that if you're calling in, and probably equally as important to do on a Zoom or other platform, but you have to identify yourself very specifically when voting. I mean, if people are participating remotely, then you need to do a roll call vote.
Okay, that's very helpful. So even if it doesn't matter how, if we're me, even if we're
Well, you were there for a while, Jethro, but you broke up.
outside, if someone calls in by Zoom, they can participate. Oh, well, thank you. I think you answered my question. I appreciate it. Thank you.
All right. Our pleasure.
So John, somebody else commented, I understood that one person, ZA or DRB member needs to be at the physical location while others can be in attendance in person or via electronic means. I think that's what you just said.
Yep. I believe that's correct. Yep.
Yep.
There has to be someone there at the physical location.
Yeah.
At least one someone.
And John, somebody else said, thank you for your very helpful overview.
Oh, my pleasure. It's our